The following program is for informational and educational purposes only and is not to be considered legal advice.
Fraudsters Radio is created to expose the many scams and frauds that have so infected society today. Scammers, fraudsters, and rip-off artists abound, whether it's scamming homeowners with bogus foreclosure relief services, dating fraud, incompetent lawyers, or consumer rip-offs. It's high time the public has a voice. If you work in a profession that deals with fraud, or if you believe you were or are a victim of fraud, you now have a radio listening public that wants to hear from you. Feel free to message us through our Fraudsters Radio Facebook page, and we may have you on the show as a guest. If you'd like to call in for today's show, the number is 646-668-8512. And welcome to the show. Storm.
Hey, Laurie.
Storm, how are you doing?
I'm fine, Laurie. How about you?
I'm doing good. I want to introduce Storm Bradford, owner of Mortgage Fraud Examiners. And Storm, why don't you tell the public a little bit about you?
Well, besides being your co-host, I've had a litigation support company for almost 40 years. We trained attorneys on how to win novel-type cases. We had one of the first innocence projects in the United States, helping wrongfully convicted people get out of jail. And we just went on from them, doing criminal defense stuff to civil cases. And out of the litigation support company, about a dozen years ago, we started Mortgage Fraud Examiners to help homeowners who were in a battle in trying to save their homes. I also have another entity that got created out of that we examine just notes for pension funds and hedge funds that buy these notes from the major players like Fannie Mae and Freddie Mac. And they come to us to have us analyze their notes as well.
Okay, now I'm going to introduce myself. I am Laurie Z, and Storm, my co-host. I am a nationally syndicated radio host and a consumer advocate, as well as a credit consultant. And, Storm, let's talk today about pretender defenders. That's a kind of a term you coined, pretender defenders. Let's tell people what that means, and then let's talk about some of the pretender defenders.
Well, a pretender defender is basically an attorney who holds himself out as a foreclosure defense attorney who is allegedly there to help homeowners in their battle against the bank. Unfortunately, most of these so-called pretender defender stall attorneys, is another word that we have for them, are committing malpractice. Why are they committing malpractice? Well, foreclosures are breach of contract cases. The bank is alleging that the homeowner breached the contract, and if the homeowner failed to make timely payments, they are breaching the contract. Also within that contract, there's a clause that says that if the borrower fails to make these timely payments, they agreed that the bank could take the house. So the only way to find any problems with that contract, obviously, is to analyze that contract to see if there's anything there that the homeowner can use as an offense or a defense to keep that bank from taking their homes. The problem is these lawyers, because they don't know how to analyze these contracts, because they don't know how loans are underwritten, they don't know if the appraisals were done properly or not, they understand that the homeowner breached the contract, so the only thing they do is stall. But stalling isn't helpful because there's 4 places in every contract where the homeowner agreed that they would pay the bank's legal fees. And the banks now, because of all these frivolous lawsuits that are being filed, are now asking for these attorney's fees, and sometimes are well over $100,000.
So the whole thing is a bit crazy, because I can tell you over the years, I have personally, because I get a lot of clients or people calling me up as a consumer advocate saying, help, this is what's happening on my house, and so I'm going to hire this attorney, and they'll give me the name of the attorney. And then my first question is, well, how many cases has your attorney won? And so every single person at that point went, well, what do you mean? And I went, how many cases did your attorney actually win? And the answer is, well, I don't know. And I go, well, don't you think you should find that out before you hire an attorney? So that it's in itself is a pretty big issue. But I myself sent out probably now anywhere between 100 and 200 letters and emails and posts on Craigslist, out of desperation over the years to try to be able to help people find attorneys that would actually help them fight. And do you want to know, I want to share with you what some of these attorneys said to me. They would either say things like, well, I'm not a litigator. I don't want to go to court. I just want to, charge the homeowner a monthly fee, which sometimes is the amount of the mortgage, and just, file the documents and the pleadings, whatever, a couple times a year. Meantime, they're charging the homeowner, like, say, maybe $12,000 a year if it's $1,000 a month, and the homeowner has no idea of what's actually going on because the attorney really doesn't do anything. So in talking to some of these attorneys, Storm, I had one that even said to me, well, I'll pay you for any leads, on foreclosure events. So I'm thinking, you can't do that. That's not even legal. So it's very difficult to find someone that wants to go out and fight the bank. Why is that?
Well, they can't fight it because they don't have any evidence. I mean, if you're in most states are non-judicial states. The reason why they're non-judicial states is because the legislatures looked at these foreclosures as a breach. They understand it's a breach of contract case. And they said, look, we don't need the court system because this is, in essence, a confessed judgment. The homeowner said, if I don't make timely payments, you can go ahead and take the house. It's just like if you financed a car and didn't make payments, what would happen? They come by with a tow truck and they tow your car away. Why? Because the language is the same. So even in the judicial states, the bank comes in, says, Your Honor, here's the contract between Mr. Jones and myself. Let me draw your attention to this clause in the contract where Mr. Jones agreed that if he didn't make timely payments, we could take the house. Your Honor, here's the proof he didn't make timely payments. Well, if you don't have some evidence that there's a problem with that contract, for an example, appraisal fraud, it was purposely overappraised to get the loan done. There was some sort of other predatory loan problem, which is unique to mortgage contracts, is there's statutory and regulatory mandates that must be followed, and sometimes the banks don't follow them. There's appraisal fraud, broker fraud, title company fraud. There's errors in contracts. There's set-offs in contracts. There's, negligence on the part of banks and any other and sundry type of problem that could be wrong with it. Well, unless you examine that transaction, you're never going to know. So when that judge turns to you after the banks put on their case and turns to you and say, what say you, sir? You better have some evidence, because if not, your house is gone.
Okay, so going back then to the pretender defenders, why, I hate to say this, why don't they explain to the homeowner all of this? Is it because, to me it seems like greediness, like they just want to take the money of the poor homeowner who's thinking, that the homeowner thinks, hey, I've got a chance here because I have an attorney. But, the attorney, if they don't know all these things that you're talking about, is that where you're talking about the malpractice end of it? In other words, the attorney should be doing this part of it, but they're really not doing anything.
That's correct. In any other type of case, for an example, let's say that someone had a contract and there was a breach. It doesn't matter which party breached it, but if you're one of the parties to the contract, you call a lawyer because you either want to prosecute the case or defend the case. You call the lawyer, and what's the first thing that lawyer is going to ask you to bring with you besides your wallet? That's the contract. Why? Because he needs to examine that contract to see if, in fact, what you're telling him has any basis. So it's matter of fact, I'll just give you a real-life scenario just to back this up, and this just isn't my opinion. I purposely called 4 to 5 different bar associations around the United States, north, south, east, and west, and I asked the same question. I said, if someone comes into a lawyer's office with a breach of contract case, and that lawyer fails to analyze that contract to find out if there's anything that he can use to help his client, is that malpractice? The same word was used by every one of them. Absolutely.
But then why don't they do anything about it? Why don't the bar associations do anything about it?
Well, to their defense, because nobody complains. Because what these stall attorneys do, what these scammers do, and their useful idiots do, the ones that basically just propagate their lies, is they tell these homeowners when they lose, I told you these courts are corrupt. I told you these judges were in the bank's pocket. That's why you lost. That's not why you lost. You lost because you had no evidence to give the court. It's plain and simple. And to their defense, they don't know how to examine these transactions. We had a lawyer that's been a lawyer for 45 years, and we did an analysis for his client, and he called up and he says, Storm, he says, I want you to know this. He said, if I'm a lawyer here now 45 years. If you gave me or any other lawyer in this country from now until the end of this millennium, the next 82 years, there is no way that any of us could have identified what you people identified in that transaction. We don't know how loans are underwritten. And he said, USPAP guidelines? I'd never even heard the term until we read it in the appraisal section of your analysis. Lawyers don't know this. But we do know that the homeowner breached the contract, so the only thing we really can do to help them is to stall as long as we can.
So is there a way to educate the bar associations to, in turn, educate the attorneys as to what should be happening? Because I know, you started your company, Mortgage Fraud Examiners, to help people because no one seems to actually do what you do. But if the lawyers don't know how to utilize it, and let's say they have a client that goes through your examination process, how do you help that attorney? Do you charge the attorney anything? Do you just kind of explain everything to the attorney?
Well, let me preface that by saying when we first started out, we were getting all these calls from attorneys around the country. How do you win these foreclosure cases? And we said, just as I'm explaining here, that you have to analyze that mortgage transaction. So we thought that what we would do is we would just educate attorneys, because that's part of what we do. We show them how to win cases. We write briefs for them, pleadings, jury instructions, whatever needs to be done. So that was our basis to start, was just to educate attorneys. And it became abundantly aware to us almost immediately that there's no way that we could train attorneys in the amount of time that would be needed for them to be proficient to do one of these, because it would take them as much time as it took them to go to law school as it would be to learn this stuff. So right. we just decided, we said, hey, we'll just analyze the transactions for these attorneys and then let them use the evidence that we provide in court. So that's what got us started in actually doing the analysis. So, an attorney, as a rule, in their defense, again, doesn't know how to do it. We don't advertise, so everything's just word of mouth. That's how we do things. So because people don't know we exist, only by referrals, the vast majority of people are out there and they're suffering the consequences of not having proper help.
Right, and that's how I actually found you when I had clients call us through a friend who said, hey, you've got to talk to this guy, Storm. And Storm, you're the only person that seems to actually understand how it works. The frustration factor I think a lot of people feel is that they think they're going to win because of the attorney they hire. They don't really know any of the background of the attorney. They don't know that they can go to court records and look and see. And attorneys, aren't they supposed to tell you, how many times they've won? But that's the frustration factor, is all the odds are stacked against that homeowner, but it's adding insult to injury. You're adding insult to injury when you hire an attorney that's not actually fighting on your behalf. They're just kind of waiting for things to happen rather than offensively going after whatever, the real issues are, right?
Exactly. And the problem is, too, is the homeowner doesn't know what questions to actually ask. And you think that it would be fundamental, but, if a homeowner goes in, the very first question they should ask is have you ever done
And we'll go to a quick commercial break.
Have your house payments skyrocketed under an adjustable rate mortgage? Have you been laid off or had your hours cut? Are balloon payments coming due? You need help from mortgage fraud examiners. To stop the housing crisis, Congress and the White House are pinning their hopes on homeowners renegotiating their mortgages. The trouble is, the banks are saying no 80% of the time. Mortgage fraud examiners can help you get the leverage you need to turn things around. They estimate that up to 85% of all mortgages are legally deficient. Mortgage fraud examiners can perform a mortgage transaction analysis and an appraisal to find legal deficits in your mortgage. It's like CSI for your home loan. Banks and lenders suddenly start cooperating when faced with a lawsuit for violating lending laws or appraisal fraud. Find out how mortgage fraud examiners can help you. Visit Mortgage Fraud Examiners. Call 844-920-7200. That's 844-920-7200.
And Storm, I know you got cut off there by the music, but let's go right back to what should homeowners ask?
Well, again, you think it would be a fundamental question to ask, but, unfortunately a homeowner comes in, they think that they're going to get legal help, and without having to ask questions, they go in and say, look, I'm being foreclosed on, can you help me? And the lawyer in most instances says yes. Now, they don't ask the tough question. Have you ever prosecuted or defended a foreclosure case before? If you have, how many of you won? Where a homeowner has been compensated by the bank or gotten free title to their home? If the answer is none, you walk away. We tell homeowners how to basically check out to see if somebody is a pretender defender, stall attorney or not. So what they need to do is that they've got to ask these tough questions, and some of the tough questions is to say, look, let me see 3 of your last defenses, your answers to defense. Let me see them. And if all 3 of them are basically the same, which they are in most cases, then you need to walk, because all they're basically doing is they're giving you a copycat defense. We know one attorney that we looked at his defenses, and every one that we saw was exactly the same. All they were doing was just basically putting the new homeowner's name in. So that's the problem.
So they're just using a template. But the other thing that concerned me when I looked through foreclosure defense attorneys, trying to find someone that does the offensive action, which I couldn't find. Here's the other interesting thing I did find. A high percentage of them, I'm going to say probably 60 to 70% of them, were also bankruptcy attorneys. So when you see a bankruptcy attorney next to foreclosure defense, it kind of tells a story right there, right?
Well, a bankruptcy, the only way a bankruptcy is going to save your house would be in a Chapter 13. The downside of it is that depending upon how much arrearage you have in a Chapter 13 bankruptcy, you have to be able to not only make your mortgage payment, but you have to be able to pay back the arrearage within 5 years. So if somebody has got, let's say they haven't paid made a payment 3 or 4 years and they owe, $100,000, there's no way they're going to be able to make their mortgage payment and make the arrearage payments and be able to pay it back within 5 years. Chapter 7 is not going to save your house anyway. So at the end of the day, the only thing that works, and if anybody tells a homeowner any different, they're lying to them. You have to analyze that mortgage transaction to see if there's something there to use against the other side. It's the only thing that works.
All right. Now, I want to talk a little bit, about the article that's posted actually on the Stop Foreclosure page on the Fraudsters Radio page, which was in the Tampa Bay News, and it's titled "Judge."
Yeah.
Tampa Bay Times, sorry. Judge, it says, foreclosure defense lawyer Mark Stopa violated numerous rules of contact. Now, Mark Stopa, I know you know quite a history on him, but it looks like at this point he's in a lot of legal trouble because he failed to tell his clients about settlement offers from the banks. So, talk a little bit about Mark Stopa and what he's doing, because I think a lot of attorneys are following this particular attorney because he's done his own great public relations job, but he's not actually helping these people. It sounds like he's hurting them.
Well, there's plenty of cases, some cases he was involved in where he defended a foreclosure victim and was never hired by them. And these people ended up in a bunch of trouble and ended up losing their home. There's all kinds of things but it's just not him. All these attorneys are doing, these so-called foreclosure defense attorneys are making these stall arguments like produce the note, MERS, securitization, assignment, standing, didn't get into the trust in time, robo-signing, a bunch of useless stall arguments that all they do is at the end of the day, the homeowner loses their home. They get a large bill from their attorney representing them, and now they're getting a large bill from the law firm who they have to pay their legal fees. And in some states, there's a deficiency judgment, and so not only do they lose their home, but they got judgments against them, sometimes at hundreds of thousands of dollars. So it's frightening, though, when I read an article like this, because it seems to be the norm, as opposed to, I don't know, I would think that if I'm hiring a lawyer who is a fiduciary, who's supposed to represent me, my interest in whatever the lawsuit is, they're supposed to be doing the right thing for me, not doing the right thing for them. And, that's what I'm seeing. And I want to read a comment, because I won't give the person's name, but it actually is posted up on the article. But someone wrote that the public needs to know the truth about this monster. This case is just the tip of the iceberg. There are many more new bar complaints and active criminal investigations of Mr. Stopa for fraud and violations of Florida law. He's not who we think he is. Close friends had a horrible experience. He actually tricked them into stealing the title to their home so he could rent it out and keep the money, and has since learned that he's done this with many other clients, including an elderly man in Sarasota where he tried to steal hundreds of thousands in equity. Even if he survives this one, I assure you he will not survive what is coming. Mr. Stopa will be disbarred, and it will be a bombshell story. That's it in a nutshell. That, to me, is frightening. Where are all the regulatory agencies that are supposed to be preventing this before it even happens? Something, you always say to me, someone's drinking the Kool-Aid. It sounds like a lot of people are drinking the Kool-Aid. Well, they are, because what you have is you have these securitization chain of title audit scammers. You have the stall attorneys. You have other scammers out there. The bank never lent you money. Other scammers telling people they have $100 million in a treasury account and they can deduct from their $100 million to pay their mortgage. All kinds of crackpot theories and so forth and so on. And then you have what I call the useful idiots. And those are the people who parrot this nonsense. And matter of fact, there's a bunch of foreclosure groups on Facebook. And I'm reading one of these foreclosure groups where this article is posted, and one person commented, oh, well, he's won 7,000 cases. Okay? And so I wrote in and I said, what facts do you have to support your comment that he's won 7,000 cases? Well, all of a sudden you hear crickets. They can't answer it. They're just propagating the lies that are out there. I've talked to thousands, tens of thousands of homeowners over the years. And Stopa's name has come up hundreds of times. Other lawyers in Florida's names come up. Other lawyers around the country's names have come up. And they don't win cases. I know the arguments that they make, they don't win cases. They can't win the cases because the arguments just don't work. Now, can they stall the case? Absolutely. Can they win it? No.
Right, because a lot of the lawyers consider the stall a win. It's really just a temporary stop in the case, temporary, until the bank decides to move forward. So I think, you told me whoever has the note, has the note. Forget about securitization. Whoever has the note, they can foreclose.
Yep. Now, part of the problem is that you might have a case where the bank comes in and the note was in transit in Florida. The note was in transit to the bank. They actually didn't have the note yet when they filed the complaint. Well, okay. They got special law in Florida that they have to have the original note when they file the complaint. So they come in, and the defense attorney, like Stoper, many of the other ones do down there, they argue, well, Your Honor, they don't have standing because they didn't have the note. Well, the court says, you're right, bank, sorry, I can't let you foreclose, but if you want to foreclose on these nice people, well, Your Honor, we have the note right here. Well, it doesn't matter. You didn't have it when you filed the complaint. So what happens? Before the ink is even dry on that judge's order, because the bank now has the note, they're down in the clerk's office refiling it. Now they bring it back. Now what they're arguing? You don't have one. So what happens is they just wasted a bunch of money.
Right. So it's basically, it sounds like it's a lot of technicalities that the attorneys use to stop, these technicalities to stop it. They don't actually fight it. You know what I'm saying? Or they're fighting it, but it's not going anywhere. And so the poor homeowner is still paying out a lot of money.
Yeah, well, actually, they don't have any evidence that has any teeth in it. For an example, up in West Virginia, Quicken Loans was ordered to pay Miss Brown $3.6 million, and that didn't include the $700,000 that she got in a settlement against her appraiser for purposely overappraising their home. So there's been, as I said, nobody has ever won any of those securitization, MERS, standing assignment, produced a note, didn't get in the trust in time, robo-signing cases. Conversely, the people that have gone in, analyzed that transaction, and went after the bank, there's been dozens of multi-million-dollar awards, dozens and dozens of free title to their property, and every conceivable type of settlement offer you can think of, well over 90% of the time. Now, this isn't me talking. This is the FDIC, the Federal Deposit Insurance Corporation. They went out and analyzed some mortgage transactions. They found that 83% of the mortgages had problems and 76% of the appraisals had problems. So if you just use the FDIC's statistics, what is the chance that there's a problem with your mortgage transaction?
I would think there would be a good chance.
And this is viable information that you can use against the bank. And you get to, instead of going and asking for a loan modification is a synonym for begging. A bank does not have to give you a loan modification. So there you are with your hat in your hand, begging the bank if they'd be so kind to give you a loan mod. Well, when the evidence is on your side, you don't go in with your hat in your hand. You go in with evidence in your hand. And now the bank's dealing on your terms, not theirs. That's how you win.
Now, is it possible for a homeowner to ever fight the bank on their own if they can't find an attorney? To help them?
Well, yes. Now, we don't, and I probably shouldn't even let this out over the air because, hopefully there's bank attorneys. They don't read these contracts either, and hopefully none of them are listening. But in every one of these contracts, there's a clause that says that if the borrower finds anything wrong with this contract, they have to give the bank an opportunity to take, quote, corrective action. Well, the only corrective action they could take is to compensate you because the damage has already been done. So the same clause of the contract calls for the homeowner to send a grievance letter to the bank outlining these problem areas that they found. So 99% of the time, you don't even need an attorney. You can do it yourself, and it doesn't even get litigated because if you have it analyzed by us, we give you the evidence. We give you the template for the grievance letter. You plug in the evidence that we found into the grievance letter. That goes off to the bank. That goes off to the bank's attorneys, and that goes to all the state and federal entities that we give you. So now you got the government going after the banks as well. It works like a shot.
Gotcha. Now, we're going to go to a break in a moment, but I want to give out our call-in number one more time, which is 646-668-8512. So if you want to be a live caller, call us now. We'll go to a break, and we'll be right back.
Have your house payments skyrocketed under an adjustable rate mortgage? Have you been laid off or had your hours cut? Are balloon payments coming due? You need help from mortgage fraud examiners. To stop the housing crisis, Congress and the White House are pinning their hopes on homeowners renegotiating their mortgages. The trouble is, the banks are saying no 80% of the time. Mortgage fraud examiners can help you get the leverage you need to turn things around. They estimate that up to 85% of all mortgages are legally deficient. Mortgage fraud examiners can perform a mortgage transaction analysis and an appraisal to find legal deficits in your mortgage. It's like CSI for your home loan. Banks and lenders suddenly start cooperating when faced with a lawsuit for violating lending laws or appraisal fraud. Find out how mortgage fraud examiners can help you. Visit Mortgage Fraud Examiners. Call 844-920-7200. That's 844-920-7200.
And Laurie Z here. And Storm, it's such a frustrating topic. One of the things, too, I noticed for you, I know in the past you've helped shut down some of the scammer companies, but one of the things I noticed on Facebook is you constantly get attacked, and yet you're the one who is right, but people want to believe things like the straw man theory where, there's really no money. How do you hold up handling being attacked as much as you do?
Well, it's not that big deal to us because the truth will always come out. And, being attacked is just part of what you do. It's kind of like the President of the United States now. He gets attacked all the time for stupid stuff. They don't look at the good stuff that he does. But I wanted to bring something up that you may recall. You and I met years ago at a conference that I gave a talk to a bunch of so-called foreclosure defense attorneys.
I remember it well.
Yeah, and I'm sure you remember we talked to an attorney, and the attorney told us that he had, at that time, 200 clients, foreclosure clients. And I asked him, I said, well, what do you charge them? Well, I charge $3,500 up front and on average about $1,000 a month. And I said, for how long? And he said, well, it depends. And I said, it depends on what? And he goes, well, for it to wind its way through the court. I said, well, a year, 2 years? He says, well, it could be 1 year, 2 years, 3 years. And I said, okay, so if you charge $3,500 up front and $1,000 a month for 3 years, that's $36,035. That's $40,000. Yeah, that's true. How many cases have you won? Well, I guess it really depends on what you mean by the word win. I said, well, let me break it down for you. How many cases did you get a financial settlement from the bank and or free title to their home? The answer, as you recall, was none.
Right.
And he also said that, well, I'm going to give you my 200 clients to have exams done, and I'm not taking another client unless they go through your firm for an analysis. Well, when he went away, I said, this guy will never send us a client. And I was asked, why do you say that? He just said he was going to send you 200 clients. And I said, because he's making too damn much money doing nothing now. What he does is he brings Harry homeowner, comes in, he immediately relieves him of $3,500, sends him on his way to start collecting $1,000 a month the next month, calls Susie's secretary in and says, hey, Susie, you know that last answer in grounds of defense that we did? Yeah, take that guy's name off of it, put this guy's name on it, bring it in here, I'll sign it, you take it down and file it. And then as it winds its way through the court system, it gets to the end. If the paperwork's in order, the guy's house is gone. If it's not, they just refile, and then the guy's house is gone. So that's basically what goes on.
Yeah, so what disturbs me about that is the attorney's not really acting as if their client's best interest. They're acting on their own best interests. And that's why I think we're starting to see more articles about attorneys and what they're doing.
Well, you're going to see more and more. And there's another one down there. His name's Neil Garfield. He's on there after him now, too. Now, here's a guy that makes Mark Stopa look like a choir boy. He's probably personally responsible for tens of thousands of homeowners losing their homes because he has a site called Living Live. It's a good name for it because 99% of what he says on that website is absolute nonsense. We have probably over the years, I don't know, at least 100 people that have complained about him. We had one client that called us up here about a year ago and said that he paid this guy Garfield $35,000. They went to court and literally got laughed out of court. The judge, how dare you come in here with these nonsense arguments? And then he awarded the bank $127,000 in legal fees and sanctions. And
wow.
I've heard many stories like that. We had a woman call us up here about 2 or 3 weeks ago that worked for him that I told her, I said, look, I said, you work for that guy, then you should know that he tells everybody he's won all these cases. You should know that he's never won a case. She goes, no, that's true. He's never won a case. Nobody that he's ever consulted to has ever won a case. And according to her, he stole $33,000 from her, and which he's done to other clients. And he sells
these poor people, the poor people lose all their money. To not only are they losing it to their house, their home, but they're losing it to the lawyer that's supposed to be helping them. That's pathetic.
And the problem is, Laurie, is that the homeowner doesn't understand. All they know is that they go in, these stall attorneys inoculate them up front, telling them how the court system's like this. They're, you can't trust them. They're in the bank's pockets, as I said earlier. And so they're inoculated with this. So when they lose the case, the lawyer says, I told you, this is the courts. I mean, you look like Stopa, Widener, Tickton Group, all these so-called foreclosure defense attorneys in Florida, Garfield, all of them. You see them trashing the judges all the time. And that's one of the things that they're after Stopa for. And all of them do it. And I'm in shock that the bar hasn't already disbarred most of them. Because what they're doing is fraudulent. They have to know that what they're doing is fraudulent. Now, to some of their credit, they will tell the homeowner that all they're going to do is stall. They'll tell them that up front.
Okay.
The majority.
Well, that's an honest thing, but it's when they lead them on to believe that they actually, have a chance of winning their house when they're not actually doing anything to help them win. And I just find that hard. I know it's happened to a lot of people, and I still get calls like that. People are losing their homes. They're in a panic. They're going to be homeless. And now, how come the bar associations don't do anything to ensure that these attorneys are not committing malpractice? But I think you hit on something before.
Here's why.
No one complains.
Yeah, here's why. Because nobody complains because they don't know to complain. It's only when they get cheated out of money where, like, in these instances where allegedly Stofa stole these houses and stole money, and Neil Garfield stole money, and other ones that have done work that never did the work. There's been, there was a guy up in Minnesota, he's one of Neil Garfield's acolytes, that finally they disbarred him. They had sanctioned him over $300,000. They told him, you keep coming in here with these ridiculous arguments. And finally the Supreme Court up there in Minnesota said, look, this guy, he's a scourge on the public. He needs to be disbarred, which they finally did. There's plenty of these so-called lawyers that get it, that Neil Garfield has taught, that have been sanctioned. It's really pathetic what goes on. But what's happening is the poor homeowner gets hit from every side. They go to these loan modification companies and pay money to try to get a loan modification. Why anybody would do that is beyond me. You can go to HUD, the federal agency. They will put an agent on the phone with you for free to help you try to get a loan mod. Now, the bank doesn't have to give you one, so you may not get one. But you don't need to pay $5,000 to get one. You're wasting your money going to these, securitization audit, chain of title scammers. Totally useless. We have a guy, matter of fact, we're going to have him on as a guest here in a couple of weeks, that he got scammed by this company, Certified Forensic Loan Auditors. He got laughed out of court using the stuff that he had, and he's now in the process of suing them. We've had hundreds of people complain to us about that. All of these securitization audit companies are basically the same. It's just useless what they give the homeowner. It's not going to save their house. So again, the poor homeowner doesn't know what to do. They're inundated by these scammers, and then they listen to the scammers' useful idiots who sit there and continue to propagate and parrot all of the nonsense that these guys are saying without checking it out. It's terrible.
Well, that's it.
And there's hundreds of blogs, hundreds of these groups that deal with foreclosures and stuff like that parrot the lies and the nonsense that these scammers and people put forth.
But people want to believe, people want to believe what they read, and yet they don't do the due diligence to consider the source. So if they find, some of these people I see even on your Facebook page are on like 100 other foreclosure Facebook pages. Oh, yeah, and so, but they are all, they're going in the wrong direction.
Well, here's the problem that the homeowner has is, again, they believe what they're told. Now, what we do is, because of our litigation support company, we have access to all the legal search sites, Lexis, Westlaw, Fastcase, and those. We can look, we see every foreclosure cases that comes down. So what we do is the homeowner doesn't have access to that. So when somebody tells them the court said this or the court said that, and it's an attorney, they take it as gospel. Well, most times it's a lie. So what do? We put up on our website a library of these cases where the courts have all said those arguments that I mentioned earlier are nonsense.
Right.
But the homeowner doesn't have access to be able to check it out. I see it every day.
Yeah, I mean, the disturbing thing for me, what this person wrote on that Tampa Bay Times article in the comments said about Mark Stopa was he took the title to the property and then he rented it out and kept the money. That would be a conflict of interest, wouldn't it? Can you take the deed to your own client's property and then rent it out?
Well,
I mean, I'm getting this going. There's something really wrong here.
I don't know. Actually, this is allegedly what happened. If it did happen, it's bordering on criminal. Clearly, it's an ethics violation. I don't know how he scammed those people into it, but I have seen people have sent to me several instances of that occurring, not just by him, but by other lawyers that are basically doing the same thing.
And who investigates these lawyers when there are complaints? Does the bar? Yeah, but they protect their own. They protect their own.
Well, not true. Not true. No. They're not protecting Stopa. I mean, they went after him because of what he did. And now, again, it has to be pretty egregious for the bar to go after him. And that just goes to show the Stopa deal is egregious. He ripped off those two clients. But, Garfield's done the same. He's been reprimanded by the bar. It's the problem is again, it's a matter of education, is that these homeowners are drinking what I call the Kool-Aid. It's Jonestown all over again. And these people are suffering because they're getting misinformation by scammers, stall attorneys, and they're useful idiots on a daily basis. And they don't know where to turn or what to do, and they just all basically end up losing their homes. Using those statistics that the FDIC came out with, 83% of the mortgages had problems, 76% of the appraisals with problems. Okay, if you got past the first or second grade, what that adds up to, what your percentages is something wrong with your transaction. But there's nobody there that is analyzing the transaction for the homeowner and telling them that. I have people that call every day. I have lawyers call every day. We had a lawyer call here last week, and he goes, Storm, he says, my God, he says, I never looked at it that way. A foreclosure is a foreclosure. I didn't look at it that it's a contract dispute case.
Law.
He goes, my God, it is. And the light went off. And he goes, oh, my God. And, when you explain it to an intelligent person, they understand it immediately. The only people that don't understand it are the scammers and their useful idiots because they don't want to understand it. Because misery loves company. That's what all these groups are. Whiners. People complaining, I lost my house, it's the court system, it's this, it's that, it's everything else. Misery loves company, so they want company.
Right. Exactly. All right, well, let's do a quick commercial break. If you want to be a live caller, call in the 646-668-8512, and we'll be right back.
Have your house payments skyrocketed under an adjustable rate mortgage? Have you been laid off or had your hours cut? Are balloon payments coming due? You need help from mortgage fraud examiners. To stop the housing crisis, Congress and the White House are pinning their hopes on homeowners renegotiating their mortgages. The trouble is, the banks are saying no 80% of the time. Mortgage fraud examiners can help you get the leverage you need to turn things around. They estimate that up to 85% of all mortgages are legally deficient. Mortgage fraud examiners can perform a mortgage transaction analysis and an appraisal to find legal deficits in your mortgage. It's like CSI for your home loan. Banks and lenders suddenly start cooperating when faced with a lawsuit for violating lending laws or appraisal fraud. Find out how mortgage fraud examiners can help you. Visit Mortgage Fraud Examiners. Call 844-920-7200. That's 844-920-7200.
We're back to Fraudsters Radio with Storm Bradford and Laurie Z. That's me. And Storm, I know in upcoming episodes we're going to talk about different types of fraud. Today we're talking about the mortgage fraud. So I want to kind of give you a story that I heard years ago, and you can tell me what you think. I don't remember who the judge was in this case, but there was a story, I think it was in the paper a few years ago, that said the lawyer in a foreclosure defense case somehow discovered that the judge owned in the same bank that was the plaintiff, and somehow it must have been a smart attorney, but that attorney somehow had to have that judge recuse himself from the case. So I sit here and I go, well, you think most judges have some type of retirement funds, and they know that they have, banks and things in there. Is that a conflict of interest in court?
No. Now, what happened in that case, the judge recused himself. Let me put it to you this way. I have seen a judge throw out a homeowner and their attorney for coming in making all these useless stall arguments on their ear, and then the next day award millions to a homeowner who had viable evidence to show that there was a problem with that contract. So, it's, again, are there judges that, like in the criminal sense, I've seen judges, I call it outcome-based law. It was like, everybody felt as though this guy was guilty. He was guilty. All the evidence showed he was guilty. So I've seen judges that basically try to move it along and help the prosecution a little bit. Yeah, there's judges that do that. But for the most part, these judges are honorable people. They don't care. They don't care. What they care about is the evidence. If you have the evidence, they're going to look at the evidence. A judge is basically like a tennis referee. He's calling balls in and balls out. That's what he's doing. And if you put if you have evidence, if you come in, you got to remember, in a foreclosure case, the homeowner breached the contract. In the eyes of the law, he's the bad guy. If it's in a judicial state, the judge already knows why we're here. We're here because the homeowner breached the contract. Now, again, the bank puts on its evidence to show it was breached and shows how it was breached. If you don't have a viable defense or a viable counterclaim against your breach of the contract, your house is going to be gone. If you do, you will keep your house.
Right. So by doing the mortgage fraud exam, that may show evidence that would say to the attorney or to the homeowner who's using it, whoever breached first, right? So in other words, if the bank actually breached or fraudulent inducement, something like that.
It could be, like I said, appraisal fraud, broker fraud, those types of things. There's errors in contracts. There's all those types of things. The problem of it is, you don't know what's in your contract. The people that can help you don't know what's in your contract. So how can somebody help you, including the court, if they don't know what transpired in your contract? And the only argument that you have is something that's ancillary to that. That doesn't work in the real world.
Why are contracts so hard to read? I mean, on my own, I study contract law. I'm not a lawyer. I just find it interesting because of the use of words and contracts. But, when you go to close on a home, there is a 2-inch thick pile of paper that, they kind of try to rush you through. Most people have absolutely no clue what they're reading, and they're not necessarily using a lawyer. It's typically a realtor. So why aren't contracts written more to the layman rather than to the lawyers, or does that all go back to the money?
Well, you're asking a question why. I mean, there has to be certain things put into contracts, but, arguments like that don't hold up in court, because if it was that easy, I have a contract with you, Laurie, you loan me $300,000 to buy a piece of property, and then I come into court and say, Your Honor, I didn't understand what I was reading. And the lawyer says, oh, Mr. Bradford, you poor thing, you didn't? Laurie, go on, get out of here. You're not getting your money. Poor Mr. Bradford didn't understand what he was reading. It don't cut it.
Right.
If you signed it, you obligated yourself to it. If you didn't understand, you should have brought a lawyer with you. That's not an excuse.
All right. Now, we got about 3 minutes before closing. Just quickly, can you talk about noteexaminers.com, what you do for the banks?
Well, these pension funds and hedge funds and other investors buy these notes, just the notes, from the major players like Fannie Mae and Freddie Mac. Like, for example, last year Fannie Mae and Freddie Mac sold $18 billion in non-performing notes. That's as it's defined. Non-performing means the homeowner's not paying on it. Well, these pension funds and hedge funds buy them maybe at like 50 cents on the dollar. So it's good for them because that's how they pay their pensioners, because it's a good investment. So what they do is more and more they're coming to us to have us analyze just the notes, because they have buyback clauses with Fannie Mae and Freddie Mac. So if the note is no good, kind of like what we may see in a mortgage transaction, they have to buy it back. So, maybe the note's not in the first position. Maybe there's problems with that transaction, like the kind of problems that we find. So that's what they do. That's why we had to form that other company, because we're getting more and more business to do that. But at the end of the day, if the homeowner can wrap their head around the fact that they signed a contract, they agreed to make timely payments, and if they didn't, they agreed the bank could take their house, then they would know that the only way to overcome that would be to find something wrong that happened in that transaction. It's only common sense. But there's, and I've read this many places before, that the human brain shuts down when people are under stress. The logic center of the brain shuts down. So when these people are stressed out, whatever they hear, they believe. Like, there are literally tens of thousands of people who believe that they have $100 million in a treasury account. The Social Security number is the account number, and that they can go to the Treasury and say, hey, look, I got this $400,000 loan. I want to take some of that $100 million that I have in the account and give it. I mean, people actually believe that. Now,
I think it's crazy. Yeah, it's crazy.
It is crazy, but they buy into this type of nonsense. So it's not too far of a stretch for a homeowner, when they go into a lawyer's office, who they think is competent, who they think should know the law, go in there, that they're going to get some legitimate help. They're just not going to be in a position where they're paying a bunch of money just to have their transaction stalled.
Right. Well, we're going to close up today's show, Storm, and people can go to your website, mortgagefraudexaminers.com, and you also have a Stop Foreclosures with Strategies That Really Work on Facebook, where people can join. Also, you can contact us, any listeners, through Fraudsters Radio on Facebook. So I think great show, Storm. We're going to do another one next week. Thank you for joining us.
Laurie, I think there's something we should do. In all fairness, we should give these stall attorneys, these, securitization audit, chain of title audit guys, any of their useful idiots, any of these other people making these theoretical arguments, a standing invitation to come on. I would love to hear their side of the story.
Me too. And they're welcome, and what they can do is they can contact us through the Fraudsters Radio Facebook page, send us a message, because I'd love to have some of those people on the show too. It would be really interesting. I want to thank our listeners for joining us today on Fraudsters Radio, and please join us again next Monday from 1 to 2 p.m. Eastern Time live. We want to hear your stories, and thanks for joining us.
Bye, Laurie.
Bye, Storm.
Have your house payments skyrocketed under an adjustable rate mortgage? Have you been laid off or had your hours cut? Are balloon payments coming due? You need help from mortgage fraud examiners. To stop the housing crisis, Congress and the White House are pinning their hopes on homeowners renegotiating their mortgages. The trouble is, the banks are saying no 80% of the time. Mortgage fraud examiners can help you get the leverage you need to turn things around. They estimate that up to 85% of all mortgages are legally deficient. Mortgage fraud examiners can perform a mortgage transaction analysis and an appraisal to find legal deficits in your mortgage. It's like CSI for your home loan. Banks and lenders suddenly start cooperating when faced with a lawsuit for violating lending laws or appraisal fraud. Find out how mortgage fraud examiners can help you. Visit Mortgage Fraud Examiners. Call 844-920-7200. That's 844-920-7200.